avatars or of valuable collectibles and art pieces to new ways of distributing content and monetizing intellectual property rights. The goal of our panel today is to explore the many opportunities metaverse platforms present for consumers, creators, and brands alike, and discuss some of the key legal considerations related to these technologies. We'll have time at the end for questions and from the audience at home and hear from the audience with us. But please allow me to introduce this great panel and our speakers. I'll start with Megan Carpenter. She's the Dean of the University of New Hampshire School of Law. Dean Carpenter is an internationally known expert in IP with particular interest in entrepreneurship, branding, and the arts. Her talent for driving initiatives from concept to execution has helped establish successful programs both within law schools and universities in generally. She has spearheaded the creation of innovative academic programs, including experimental learning initiatives, joint degree programs, certificate and interdisciplinary programs with various colleges across university campuses. She writes and publishes in the area of intellectual property and innovation and has written multiple book chapters in numerous prestigious journals. Then Dan Jasno, an attorney with Aaron Fox Schiff, whose practice focuses on advertising, product development and distribution, and intellectual property in the technology, fashion and retail, and consumer products industry. In addition to Dan's IP and advertising practice, Dan has been at the forefront of Metaverse, NFT, and crypto space, drawing on his experience as in-house marketing counsel at Meta Reality Labs, where he advised on next-generation consumer electronics, AR, and VR software products. Dan helps brands and creators understand how to do business in the metaverse, including advice on negotiating NFT minting and service agreements, monetization strategies, and IP protection and enforcement. Dan also helped Aaron Fox Schiff become the first major law firm to buy land in the metaverse. Thank you very much, both of you, for being here with us today. And Dean Megan, the floor is yours. Thank you.
Takeaway that I hope that you all have by the end is that this presents entirely new business opportunities, new value for clients. This is disruptive technology in its truest sense of the word, and more than ever, we need to be thinking outside the box. So we have critical components of the metaverse in place. They're these building blocks, and we can characterize them in 3 different ways. Digital technologies that are overlaid on the real world through AR, some kind of hardware that then enables the interaction. There's information about the world and data that's combined in machine learning in real time to then benefit the user experience or UX. If you think about examples, Siri would be a great example of on your iPhone of ways to, that sort of learns from you and provides the data that you need. So from a business perspective right now, the metaverse is an essential consideration. It changes our notions of and our opportunities for really basic stuff, like what it means to collaborate, how we engage in transactions, how we conduct performances, which really have historically been very human in nature, and what it even means to create. Let's take a little bit of the history right now, and I'm going to kind of gloss over but provide a couple of highlights. Back in 2005, those of us who have, 20-year-olds, I have a 23-year-old, he was all about Webkinz in 2005, and you bought a stuffed animal that came with its own code. So when you put the code into your computer, it would take you to kind of a particular game where you saw an avatar of your stuffed animal. You could play games and interact there. Club Penguin was very similar. In 2007, we saw the advent of Second Life. And so to the three really important developments Stafford mentioned this morning, I'm going to add the creation of Second Life and the launching of that, which really provides in some ways a foundation for what we think of as the metaverse today. And we'll talk more about that here in a minute. 2016, we have Pokemon Go. Takes the world by storm, augmented reality incorporated into a game. 2017, the launch of Fortnite. A universe of its own where users can play a variety of different scenarios, and there are now concerts launched and esports, and more about that in a minute too. And then 2021, Facebook reimagining itself as Meta. Let's look at Second Life itself. Those of you, I think, are probably familiar with The Office. So we'll have Second Life described to us by the character Dwight Schrute, who has rather a way with words. Can you play now?
Second Life is not a game. It's a multi-user virtual environment. It doesn't have points or scores. It doesn't have winners or losers. Oh, it has losers. I signed up for Second Life about a year ago. Back then, my life was so great that I literally wanted a second one. In my second life, I was also a paper salesman, and I was also named a client. Absolutely everything was the same, except I could fly.
So at the time when Second Life came out, we were thinking that scholars and lawyers, we were talking about how it was just going to change the world. We wrote papers, we had conferences, we talked about all of the legal frameworks that were up for grabs, but it didn't fully realize its potential. And there I think that the technology itself was what became an issue, that it was clunky and wasn't quite easy to use. The technology just wasn't there. But what it did was to set the stage in many ways. Can we bring the deck back up? Great, perfect. Let me go back. Yeah. To set the stage in many ways, to provide a foundation as we look at now how courts might approach metaverse issues. So for the first time, we're seeing that virtual property can be real property. We're still unclear about whether if an avatar has an affair, that is actually an affair in real life for divorce purposes. How do we handle jurisdictional issues? And Dan's going to talk more about that here in a few minutes. How do actions that would constitute trademark infringement in the real world translate? Is use in a virtual world, use in commerce? And these were the first times we started to get answers to some of those questions. We also get some jurisprudential stage setting as well through video games themselves. So Grand Theft Auto is a great example. And there was a case that held that there wasn't going to be trademark infringement where there was a representation of a strip club in the virtual world that was based on a club in the physical world. And the courts were really balancing, as they will in the metaverse, this kind of freedom of expression, artistic expression versus commercial trademark rights. And we're going to be seeing that more and more. Today, that's coming, the concepts are of this kind of interaction, the confluence between the virtual life and the real world are happening in a whole new way. So we want to remind ourselves of some of these characteristics as we launch into the present. Technology that involves digital content overlaid on the real world, users interacting with that digital content, and the user experience optimized. And those concepts are increasingly coming to the fore. For example, with the creation of the Metaverse Standards Forum about a month ago by several big tech names, whether you're talking about Meta, Adobe, Microsoft, NVIDIA, Kronos, Epic Games, Sony, to essentially foster the development of open standards for the metaverse. So, okay, let's launch into the present now. And just as in many issues, the entertainment industry is leading the way, including creating a lot of opportunities for businesses and industries that are not conventionally in the entertainment industry. So let's look at a few ways that the metaverse is transforming the music industry specifically, just in a little spotlight, and some of the established legal frameworks that have undergirded it, along with a few implications for that. So now, for example, there are musicians that use avatars to perform works, to interact and perform, not actually performing themselves. They can perform in a virtual venue and defy the laws of physics. You don't need permits for your pyrotechnics, right? It can be, you aren't even bound by kind of gravity in general. Negotiating agreements for exclusivity with the platform is part of that. Expanding the technical aspects of production, for example, through augmented reality and allowing opportunities for participation by the audience. Rights clearances can be a lot more complicated in this space, and it's worth pointing that out because you're going to have artist management and recording rights. We've got song composition rights, video entities that are powering the production, choreography, content that's included, technical digital artists involved in the creation of the overall production. So there's a lot that's going in here. Another component is that brands have really been leading the way as well. And they're finding new ways to engage with consumers that they haven't before. So I'll list a few ways to think about that you all might be encountering with your clients. Exclusive items in-game. That's a great example that aren't anywhere else. Lots of times it's an item that wouldn't work in the real world. Again, sort of exciting people in weird ways, and brands are really exploring the contours of that. Very excited by not being bound by the laws of physics and creative content that no longer has to obey science. There's also an opportunity to test out new products before you launch them in the real world, that kind of integration of virtual and real. Exploring new markets. So, you know, if a client is not producing lines of handbags, would a line of handbags actually work? Or developing unconventional partnerships. We can look at Fortnite and Balenciaga as one example of this. I have a 9-year-old who's very familiar with Balenciaga, and I can't imagine any example where my 9-year-old would be aware of fashion brands. But thanks to Fortnite, that's certainly the case. Let's go ahead and see the trailer. So here we see that Fashion Week, we're taking Fashion Week outside of Paris or New York or Sao Paulo. I think it was the 53rd Fashion Week that took place this year in June, and bringing that into the homes and living rooms of people of all ages through these kinds of virtual worlds. So in this context, I also want to talk a little bit about the issues that come with major networks. So major networks are joining in as well, engaging in simultaneous virtual interactions. The MTV Music Awards is a really current example of that. It's I believe on August 28th, this month, And, you know, at some point, the MTV Music Awards, this is probably back when MTV actually played videos, but viewership was about 12 million people around the world. But last year, I think viewership was under 1 million. And so as this network thinks about ways to engage consumers, they've taken a virtual approach and decided to partner with Roblox and develop this kind of unconventional partnership. And so they're going to be hosting a virtual performance of the VMAs. And they just announced a couple of days ago, 3 days ago now, that they're going to have a category that's Best Metaverse Performance.
Recording in progress.
To the awards that they give. I want to make sure that we're mentioning AI, or AIs, as Stafford was saying, as an important consideration as we think about some of the implications for collaboration and creativity. Earlier I mentioned that the tech surrounding the metaverse really changes our notions of basic creation and presents all kinds of opportunities for artists, as we saw in the music field. But there are also significant challenges. For example, content can be created without content creators. There are individual artists that are non-human, both in the visual world and also in the music world. Data is going to overlay every aspect of the virtual world. Machine learning technologies are going to assemble and analyze and use the data, and IP is going to be pervasive. There is no natural component in the metaverse. So IP is going, whether it's a tree or someone going on a hike, everything that is there is created, and there will be IP issues coming up there. So I want to make sure that we're talking too about NFTs as we kind of set the stage. So far I've given some history, talked about some legal risks, some opportunities, and some challenges. So let's quickly address NFTs as well. What are NFTs? They consist of digital data that is stored on a blockchain. They can tokenize an asset, and you can make it tradable. But they do not automatically come with IP rights attached. And there are some scholars and commentators that take the position really that NFTs are really just a license. So there's no ownership of anything at all. And purchasers really need to understand, because there are gradations, what they're buying, and sellers need to understand what they're selling. And sellers should be careful. We need to be careful as we work with clients to, as we market and advertise, and it's sort of like a digital trading card, and a lot of sports teams or sports organizations are making this kind of analogy, but without the actual physical card. Because there are differences, this is like legal tip number 16, sellers have to be careful to really clarify what they intend to sell and to attach the contract terms and conditions. And it's kind of a balance, right? Because you want things to be, you want to impose the terms and conditions that you want, but also ensure that NFTs can be traded easily, because that's part of the interest. The scope of NFTs can be significant, and I think we can all predict that they're going to play an increasing role on the stage. The early use of NFTs was in the art market, right? And the hype was really all about art. So the enthusiasm, I think, probably hit with the Beeple NFT that was sold by the auction house Christie's for $69 million in March of 2021. And what did the buyer buy? Is it essentially just a certificate of authenticity? I don't think any of us are really quite sure of the contours at this point. And it's an example of how these concepts really throw the concept of ownership into question. What does it mean to own something, and what are you owning? With digital art, it's just the IP. So with art, you would have two properties, right? Typically, you would have the tangible property, and then you would have the IP rights that underlie it. With digital art, it's just IP, but with NFTs, the IP may not come with that. So it's a creation of new value entirely, which is something that can be really powerful. Brands are seeing all kinds of ways to exploit these interests and develop new values, products, and services. So creating these outside the art market. So if it's Taco Bell creating NFTs around some of their products, or Charmin with toilet paper, often they're raising money for charity at the same time, or developing a sweepstakes in comparison. And Dan's going to talk more about this. I'll just focus for a minute on NBA Top Shot. They have seen incredible success in the U.S. with the Top Shot program, which is a marketplace that allows people to collect kind of big moments from basketball games. And it's comparable really with a trading card. And by mid-May, we saw they hit $1 billion in sales of these moments. And interestingly, the sales are really proportional to the supply. When more moments have been released, sales in general have gone down. So that's something to be aware of. There are all kinds of NFTs that are developing that are taking advantage of the opportunity not to have to deal with science, physics, and gravity. So furniture NFTs don't have to be realistic, and nobody has to be able to actually sit on this chair. In fact, we see a couple of things. Sometimes NFTs are paired with real-world services. So when it comes to furniture and chairs, there's a Meta Chair Society that has been developed. It's a collection of designers and a collection of furniture that gives access to design services in the virtual world and the real world simultaneously. Also, events have become a big part. The artist Post Malone, there's a sweepstakes component. There is, he's collaborating with a crypto firm, and you get a chance to play virtual beer pong, not real beer pong, but virtual beer pong with him as part of this release. There is so much to cover here. The landscape is wide, and it is also getting deeper and more complex. I hope that in the last few minutes we've been able to explore a little bit about where we've come from and some of the legal issues that are presented. I also hope that you have, as a takeaway, some components that are practical and yet entirely new business opportunities and value that you might provide for your clients. I'm going to turn it over to Dan now, who's going to talk about some of the great work that he has done in this space and get more into depth. Dan, thank you so much.
Thank you so much. Wonderful. Dan.
Thank you. I'll take this. Thank you. Hi, everyone. I guess you can hear me. So I'm Dan Jasnow. I'm an attorney with Aaron Fox Schiff in New York, where I do a lot of IP work, advertising and marketing, consumer protection. So Dean Carpenter has just given us a great overview of the metaverse, some of the history of it. I'm going to dive into a little bit some of what we're seeing with our client work, as well as what I've seen in my experience. I was in-house counsel, secondment to to Meta as in-house counsel for about 6 months the past year, and which gave me a great opportunity to see sort of what some of the technology is that is undergirding the development of the metaverse. So, as Dean Carpenter said, the metaverse does not exist yet in its most aspirational form. So, the truly immersive internet, the internet that might be all around us, that we will see or experience on an everyday basis, where we will feel like we are in the internet in some ways. But there are aspects, there are technologies that are being developed that are actually on the market today that are making some of these things possible, and that make it possible to see the future of the metaverse. Can we play this video, please? So you might be familiar with some of the consumer electronics, the wearables that are out there on the market, most notably what used to be called the Oculus headset, which is now the Meta Quest 2. This is a virtual reality headset that fits over your face. A similar one is available from Sony called the PlayStation VR. Microsoft has had one for a long time called the HoloLens. Is it possible to play this video? Let's see. There we go. So there's a misconception that when you put these on, you are cut off from your physical world, that you are going into a video game, that you are in a virtual reality situation. But in fact, the Quest 2 has now been opened up to third-party web developers, and they can now program these augmented or mixed reality software applications where you can see your entire physical surroundings. So in this example, the individual on the right, you can see is wearing a Quest 2, and this is his point of view. This is a software program that he developed where there's an overlay of digital content on his physical experience, and it is teaching him how to play this song. So, you know, when you combine this with some of the metaverse worlds that are out there, you can start to see this new digital experience taking shape. So if we see that, and then we can play this next video. Let's see if I can just start this. There we go. So this is sort of maybe where we're headed. And this is a video from Adobe, the software developer. They put on smart glasses, and then, you know, when they wake up, they can see the temperature and the time. They see a virtual pet that they have. They're presented with their calendar. They can turn on some music. And they're presented with all sorts of information. And really, you start to see this is the immersive internet, right? That's what the metaverse is. It's not cutting yourself off from your physical reality. It's bringing the internet to you. It's getting away from looking down at your phone and instead looking up in the physical world and having that additional sort of benefit of the internet come to you. And you can, you know, obviously this just raises a whole host of new applications, especially where, as Stafford talked about, you have companies that are creating an ecosystem for third-party developers to begin to create these apps, like the piano app that we just saw, where you know, you can be using this new hardware, building new augmented reality software applications, and create lots of new opportunities. So those are a couple examples of sort of where we currently are with the state of technology, where we might be headed. I'm now going to talk about some examples of brands that are actually in the metaverse. So the first we're going to look at is Decentraland. So Decentraland is a metaverse world, one of the metaverse worlds. It's built on the Ethereum blockchain, so it's what we call an on-chain, a true Web3 metaverse world. And within Decentraland is this fashion district, which hosted a fashion week back in March of this year, a virtual fashion week. And throughout it, you can see all these three-dimensional stores with major brands in them. So Dolce & Gabbana is here, Elie Saab. Each one of these experiences is completely controlled by the individual brands. So there's no Facebook, you know, developer behind this that is creating this on behalf of the brand. The brands are coming in, creating a virtual experience, and consumers can come in here and shop in any of these stores. So if this is an example, this is my avatar going into a Chufi store. And again, you can see this is a completely immersive experience. This has been completely designed by Chufi. They own all the IP in here, and they control all the IP. It has virtual mannequins that have real Chufi authorized virtual goods. You go up to the second floor, you can see a Chufi ad that's on display here. And then there is an e-commerce component of this. So if you go up to one of these virtual mannequins and you click on it, it will redirect you to a marketplace that is Decentraland's marketplace, where you can purchase virtual goods. And again, so this is a real brand that's here. The brand controls all the content. They control the experience that the user has. And then there's an e-commerce component where I could go in and buy this virtual kimono from Chufi. Prices are in cryptocurrency, so Mana, which is the native currency for Decentraland. And if I purchase it, then I can wear this, throughout Decentraland. So, this is a whole new e-commerce experience for these brands, and it's a whole new revenue source that, doesn't rely on supply chains. You don't have to be shipping over, apparel or fabrics from China or somewhere where you have to be worrying about shipping delays and costs. This is pure IP, a whole new revenue stream that brands are really jumping on. This is another example, another Decentraland application. This is Patron Tequila. In order to access this content, you have to go through this age gate. So Patron, again, is in control of this content. They've created a digital experience that is completely immersive. But I think it's interesting because, Decentraland is sort of the cutting edge, but the brand is still in control of this experience. They're making sure that they're complying with US regulations through a pop-up notice. They're age gating this content. They're offering a sweepstakes here, so you have to do various things in Decentraland in order to enter the sweepstakes, but they're also restricting it to US-only consumers. So, cutting edge sort of experience, marketing and activation, but still, going back to the key tools of compliance in the US, age gating, restricting eligibility. Nike Land is another one. Nike has been a really big player in the metaverse so far. In contrast to Decentraland, which is pretty much owner-controlled, so the brand owner can control all the content within Decentraland on whatever land they've purchased. Nike Land is a partnership with Roblox, which is one of these sort of more traditional Web 2 video game developers. So they've entered presumably into some sort of license agreement with Roblox. Roblox has developed it for them, but it's fully immersive. It's like a video game, but with all Nike content. You can go in there and play virtual basketball and run virtual track and play virtual soccer. And then you can collect various Nike-branded gear and dress your avatar in it. So it's fun. And the other thing is that they've attracted 7 million viewers in the first 5 months. So a huge amount of eyeballs on that and great marketing for them. 2 other brands who I just wanted to flag are really big into this space, L'Oreal and LVMH. Both really see this as an opportunity to engage with their consumers for storytelling, for community building. As Stafford talked about, this is a lot about how do you reach the next generation of consumers who want the experiential component. They may not even care if they're getting the physical goods, but both of these brands are also doing mixed offerings where you're getting digital goods as well as physical apparel if you purchase an NFT, for example. Like Dean Carpenter talked about with the NBA, the NFL in the US has been really big here. I'll just flag that their marketing emails for NFT commemorative tickets for game tickets. So you went to a physical NFL game, you got a commemorative NFT ticket stub. They saw an open rate for their marketing emails about this for 75% open rate for these marketing emails. 500,000 of these NFTs were claimed by consumers, and that 75% open rate compares to a normal 20% engagement rate for their marketing emails. So huge amount of engagement for these. So that's some examples of where brands are. I'm going to talk a little bit now about what are the key legal issues that are coming up with our clients when we are working on these metaverse type activations. First thing that everybody is focused on is that this is really the new IP gold rush. So new trademark registration or trademark applications. We're seeing a ton of activity in 9 for virtual goods and services, 35 for online retail, and 41 for entertainment. Those are sort of the core classes that I'd say we're filing in for clients, but there are also ancillary classes like 42, depending on what kind of activity you're doing. If you are actually going to be issuing a cryptocurrency token, that might affect what classes you're going to be filing in. But a lot of registrations are happening, raises a ton of copyright issues, especially for big brands. Number one, how they're protecting their copyrightable works in the metaverse and enforcing their rights. Blockchain domains are really big. We're registering a lot of blockchain domains for clients, which we'll talk about, and of course virtual real estate, which is essential if you're going to be in one of these Web3 on-chain metaverse worlds. So this is just sort of a visualization of what the different metaverse worlds are. So I showed you some examples from Decentraland as well as Nike Land, which is a Roblox partnership. On the right side here, you have sort of the true Web3 metaverse worlds. These are immersive applications that are built on the Ethereum blockchain for the most part. And in each one of these, the brands control the IP to a degree that they have not been able to in sort of Web 2 applications or social media. So they're mostly run by a decentralized autonomous organization, and run is sort of a generous characterization of that. The DAOs essentially set up these applications, and then they sell off all the different virtual plots within them, and then the landowners control how the application proceeds or is governed. So Aaron Fox Schiff purchased land in Decentraland, so we are a landowner in Decentraland. We could theoretically vote on, what the policies are going to be in Decentraland, and then we retain pretty much all control and rights over the IP that we upload into the system. In contrast, Zepeto, Fortnite, Roblox, Horizon, those have the same sort of superficial characteristics of these Web3 on-chain worlds, but they are not built on blockchain. They don't have this notion of true ownership, and they're largely still controlled and developed by big tech. So Horizon is from Meta, and then Fortnite and Roblox, as well as Zepeto, are all developed by major video game developers. So in a lot of ways, they share characteristics more with the social media platforms than they do with the Web3, but they're sort of in the middle. And they're different. So if you're working with clients who are like, well, I want to go into the metaverse, which world you pick makes a big difference in terms of what the underlying technology is and what your level of control will be as a brand. As Dean Carpenter talked about, NFTs are a big part of this space, and the quality and nature of NFT transactions varies very significantly in the marketplace right now. We're seeing a lot of confusion in the marketplace about what is the nature of an NFT transaction, what rights are you getting if you are a consumer and you are purchasing an NFT. There's a lot of advertising out there that says you own this tokenized asset, but in fact, in most cases, the consumer does not own the tokenized asset. They might own the token, which is the smart contract that is on the blockchain. That's like your digital receipt, but that doesn't give you any real control over the copyrightable work that is the tokenized asset. So given the value of some of these transactions, we think, I think it's fair to say that this is a looming class action in the US risk, as well as a regulatory risk where a regulator is going to step in and say, you're misleading consumers about the nature of this. So as a brand, you really have to understand what rights are you giving to consumers, what rights do you want to sell. As a big brand, you might prefer not to sell the copyright in the underlying work. You might prefer to grant a license, but you need to make sure that the way that you are communicating that reflects the true nature of the transaction. Another area that I think a lot of brands are very worried about is enforcement of their IP rights in the metaverse. And there's good reason to be worried about that. As we talked about, in these on-chain Web3 worlds like Decentraland, the Sandbox, there is no intermediary. So these are unscripted experiences. The brand owners or whoever the landowners are control the IP that's on there. But in fact, we've had relatively good experiences working with these worlds, just submitting sort of traditional cease and desist letters, takedown notices. This photo was an example of an unauthorized Walmart store that only sold Pop-Tarts. This was in Decentraland. But, in some ways you see this and you think, well, we're never going to be able to get this taken down because we don't know who put this up. We don't know, who owns this plot. But Decentraland has been pretty responsive, as have some of the other Web3 worlds. Whether or not that would still apply if you're a less well-known brand than Walmart or Ferrari is another one we've had success with, that I think remains to be seen, and whether or not they'll actually take action for smaller brands. So as I mentioned, blockchain domains are another area that there's been a lot of client interest. Blockchain domains they're not exactly like regular domains. The key application for blockchain domains is that they are they can serve as a nickname for a crypto wallet. So if you are Chufi, for example, that's going to be accepting payments on Decentraland for virtual goods and services in cryptocurrency, then they could register, let's say, chufi.eth, which is a blockchain domain extension, and then they could use that to collect payments. So normally, each wallet address is, say, a 40 to 50 character alphanumeric string that you have to send cryptocurrency to. Instead, Chufi can say to their consumers, hey, just send us, you'll send mana to chufi.eth instead. They can also potentially, and this is probably more, down the road, be used as web addresses for decentralized websites. The key thing to know about these is that they're very difficult to recover if they have been purchased by someone else. There's really no recovery mechanism for .eth domains, which are the most popular, I would say. So if somebody else owns it, which I guarantee you they do for almost every client that you're thinking of, then you either have to wait till it expires and then you can register it through a reverse auction, or you can try and acquire it from the current holder by some extortionate amount of money, or you can, sort of go to war against the current owner, but that's going to result in them probably burning the token, which means that nobody will ever be able to use it again. There are some other domains which are part of a brand protection program. Those are all domains that are managed by Unstoppable Domains, which is sort of like a traditional registrar. We've had some success with that, getting protected domains, and they are fairly responsive about adding new brands to their brand protection program. So that's a great option if you have a client who they're not ready to purchase things, but they really want to make sure that their IP is protected, at least for some of these domains. Bottom line, though, is there's no UDRP process for this, and there's not anything sort of coming down the pipeline that's going to give you that type of third-party mediation service that will say, okay, I recognize you as a brand holder, here you go, you can have this. These are essentially first come, first serve. A lot of jurisdictional considerations in these platforms. I'd say you can divide these into sort of the business-to-business jurisdictional considerations, which are what jurisdiction are you agreeing to if you as a big client are going to be purchasing land in one of these on-chain virtual platforms. We're seeing a lot of offshore jurisdictions for these platforms, so Cayman, British Virgin Islands, Panama, Hong Kong, is where a lot of the terms of service, the DAO terms of service, are selecting. And then there's the business to consumer element. So if you are a brand who sets up some sort of brand experience, like if you're Patron who sets up a brand experience in Decentraland, you can still impose your own jurisdiction on consumers who come to visit your experience, and that's what you can see here. This is a casino in Decentraland where you can go and actually play poker, but before getting there you have to agree to their jurisdiction, their forum, selection clause, etc. So that's a pretty traditional, again, tool that you as a brand can have when you're setting up your own experience, but you're still going to be agreeing to Panamanian jurisdiction if you get into a dispute with the Decentraland DAO. Franchising and licensing agreements are just another issue I would flag as an important jurisdictional consideration. We're seeing a lot of activity where clients are carving out metaverse rights in some of these agreements. So if you have master franchisees in certain countries, you want to make sure that you as the ultimate brand owner have control over the metaverse experience, and that your country-specific franchisee does not have the rights to go into the metaverse, because of course there's not really any way to prevent consumers from one country from going into the metaverse in a different country. So making sure that you as the ultimate brand owner control those rights is an important part to making sure you have a clean brand experience in the metaverse. NFT minting agreements are another area that we are doing a lot of work for clients on. A lot of clients who may not be looking to go purchase land in an on-chain metaverse world might still want to license their IP to a third-party vendor to sell NFTs or to put their digital goods in Decentraland. There are a lot of vendors out there that are offering this to brands, and the agreements that they're offering, the nature of their services, their level of sophistication varies very significantly. We're seeing a lot of really junky term sheets presented to clients, and then with royalty structures that are sort of all over the place, and with cost shares that are all over the place. So I think we've seen term sheets that say the brand will get everything from 95% of the revenue to 30% of the revenue moving forward. So you want to be really closely scrutinizing these agreements. Royalties are really important because, as we heard, you can resell NFTs, in perpetuity theoretically, and the brand can write into the smart contract that they will get royalties on every one of those sales. So these are major opportunities for sort of long tail revenue opportunities. But if you don't structure that correctly at the outset, you can lose that money entirely, or you can, it can be written incorrectly, so it doesn't function. So, a lot of really technical issues that you want to be focused on when you are looking at these for a brand. And then finally, just one US case I wanted to flag. This is Nike versus StockX. Nike, obviously, we saw is very involved in this space. They've been very aggressive at protecting their rights. They filed a ton of trademark registrations. and they've now become one of the first to file suit against a arguable infringer. StockX is a really interesting company. They essentially warehouse physical collectible goods. So whether that's collectible apparel, collectible bottles of wine, if you buy one of their collectibles, they will store it for you. If let's say you're purchasing a bottle of wine as an investment opportunity, really, and so you don't even want them to ship it to you, they'll hold it in their warehouse until you decide to resell it. They're now issuing NFTs that are certificates of ownership or title for their collectible goods that are sitting in their warehouse. So in this example, StockX has issued these NFTs for collectible Nike sneakers. I don't know if anybody in here is a sneakerhead, but like some people are really into collectible Nikes, like Air Jordans from the 90s or whatever. They can become really valuable. So they have all these NFTs that they've issued that show title for or are title to actual physical Nike sneakers. Nike is saying this is trademark infringement. We have our own, we're doing our own activations in the metaverse. You guys are taking away from us. StockX is saying this is fair use, for sale doctrine. This is no different than if we were, reselling Nike sneakers in the store. But in fact, these NFTs, according to Nike, provide all sorts of additional benefits like access to special events, rewards, experiences. So that's probably where this case will turn. What is the consumer actually getting when they purchase this NFT? Is it just title to physical Nike sneakers, a single pair of physical Nike sneakers, or are they getting something more? But this case is ongoing, and it's one that we're watching very closely.
Thank you so much. I think we can all agree that we can stay here for another 2 hours just getting deeper into these issues, but thank you, both of you, very much. I have a few questions prepared to ask our guests today, but I feel like there could be a lot of questions from the audience. So please feel free to raise your hand and ask for the mic. I'll ask one question while we get warm up here. Dean Carpenter, the Pigpen and Playpen strip club case was litigated in 2008. The court in that case took the relevance of the artistic test, but also addressed the likelihood of confusion between the use of a real-world strip club copycat brand into a video game. If we're in the metaverse world now, do you think the courts would look at this differently? Would brands have more of a bite when it comes to fair use defenses? How do you see that?
Fernanda, that's such a great question, and I'll give a couple. I do think it could be different for two reasons. One is that commerce is taking place in the metaverse on not an ancillary basis. So the use of someone's brand or setting up a shop isn't just part of kind of the artistic expression, but brands are routinely setting up their own existence on these platforms. And so I think for that reason it can be materially different. I think the second reason is that because of that, consumer expectations are very different. So consumers are very much more likely to be confused because they see the Chufi store and think, okay, that's clearly a Chufi store. And then if they see something else, you would be inclined to think that there was a licensing right. I will give a couple of examples that have been recent examples that do give me some pause, and it may just mean that courts have to get used to this new environment. One would be there was a case, both U.S. cases. There's a case from a saxophone player who went viral for his dance moves. So to play saxophone and dance at the same time, I can't imagine doing both. But he has these dance moves while he plays, and Fortnite set up, had a saxophone player that had remarkably similar dance moves. So in that case, the court dismissed the right of publicity action and dismissed the trademark action. They allowed a false endorsement to go forward. But I think that is sort of one concerning flag. And then the other case I'll quickly mention was AM General. It was about Humvees and the portrayal in Roblox of having, in Call of Duty, the video game Call of Duty, of having Humvees represented there. And the court there said that the use of Humvees, even though they were a protected brand, had artistic relevance because are used by military operations all around the world. So it was portraying something that was realistic in real life. So those are sort of two cautionary tales, I think, for brand owners. But I do think sort of the overarching situation is materially different.
Wonderful. I don't know if we have any questions from the audience. Please, wonderful. Let's just get the mic. Thank you.
I think it's for Dan. You know, in that Nike case, is there a consideration by the judge on jurisdiction? Meaning, for instance, is there any judge that would say this is not the appropriate jurisdiction to litigate that? And, you know, how do you deal with that? Do you have any Supreme Court decision already?
Yeah, that's a great question. I think in this case, the jurisdiction is, I think, pretty clearly U.S. because the StockX actually has a physical presence in, I think, in the Midwest somewhere, although I could be wrong about that. And the NFTs are subject to, you know, fairly traditional website terms of use that set the governing jurisdiction in the U.S. I think there could be jurisdictional considerations for a similar case, say like Decentraland, where the terms of use are Panama. If you as a brand are trying to litigate, like if Nike tried to sue the Decentraland DAO for infringement, I think in that case, in the U.S., you would at least have an argument that there's not jurisdiction because Decentraland is not, they're not based in the U.S. They have no presence, as far as I'm aware, in the U.S. So, you know, that raises a number of different questions. You could then say, okay, well, if I don't have jurisdiction over the DAO, do I have jurisdiction over the infringer? Because, again, in Decentraland and these on-chain platforms, you have both the DAO, which sets things up and sort of just pushes the ball down the hill, and then you have all the landowners who are within the platform who can set their own terms of use, who can set their own jurisdiction, and might be either major brands or they might be some small infringer. If you can figure out where they are, or if you can get jurisdiction, maybe they're selling something infringing and you can purchase that as a U.S. consumer, you know, maybe you can get jurisdiction that way. You know, there are going to be lots of questions about that stuff. I think a lot of that is untested, but it raises a lot of novel issues.
Wonderful. Thank you.
You asked me to stand up. Valdir Rocha from Rio. Question to the panel, either one can answer. We've had quite a bit of experience in takedown notices on social media, Instagram, Facebook, etc. What is your experience with takedown notices in the Metaverse platforms?
Perfect. Can I pick back on that question just to ask you along the same lines? What's your experience? And you mentioned the Walmart case, successful takedown enforcement case, but we're talking about a global brand, notorious brand, well-known brand. If you're talking about not as global as a Walmart brand, what are the other IP considerations that would make your case stronger that you've seen help in takedown procedures, I guess, with the platforms?
Yeah, those are great questions. So I'd say our experience so far, we have submitted a number of takedown notices into Metaverse platforms. And our experience so far, I would say, has been we've seen a lot of cooperation on the part of the platforms, but that is almost entirely voluntary. So they have been, as Fernanda pointed out, willing to take action on behalf of some very large global clients who, you know, have famous marks, et cetera. If I don't know that they're going to be willing to do that in the future, especially for some of these on-chain platforms like Decentraland and the Sandbox. So, and of course, you know, we submit a lot of these takedown notices that we submit to social media companies are under the Digital Millennium Copyright Act in the U.S., which creates this whole structure for them to, you know, you provide notice, they take the content down, then they potentially forward it to someone else. That does not exist for a lot of these platforms, and because they're offshore, they're not technically obligated to comply. We're seeing that they are complying, but whether they will in the future and for some of these brands is unclear. because of that, I think it's really incumbent upon the brands, especially smaller brands, to make sure that you have adequate protection, particularly on the trademark front. So if you are a registered, or if you're, maybe a smaller brand, you might want to think about, do I have trademark registrations in the jurisdictions where some of these platforms are based? So do you have Panamanian Metaverse trademark applications? Do you have Hong Kong? Do you have Cayman? There's going to be a very important balancing decision to be made there. Is the cost worth it? You might want to try submitting takedown notices before you launch a big filing, but maybe you want to file one multi-class application in Panama if that's where you're seeing a lot of activity. And then copyrights too. I think to the extent that you can show an original work, right? So if you can say, here's a link to my website where there's a photo of this, here's a copy of the original work that's being infringed on Decentraland, I think you might, get a good response from the DAO or the DAO's general counsel. But if you don't have that and you're not a big brand, we'll see.
Wonderful. We have one more question. We only have 1 minute and 40 seconds. I think I just want to comment in this 10 seconds that it's clear to me at least that the more you can anticipate these legal issues as our clients are getting into the metaverse, and as you said, from the get-go, make sure that the smart contract is thought through to anticipate these things, and maybe even look in the portfolio of your clients and say, look, you're not as robust here as if you're choosing a platform, be proactive. I think that's fair to say. Please, go ahead.
Hi. Congrats for the presentations, really good. When we talk about real products, it takes a while for them to be developed, to be created. So we as IP councils, we do have time to plan registrations and get protections. But it seems that in the metaverse, things will be very dynamic, very fast. And it simply will be very difficult to get registrations quickly in order to get protection. So how can we deal with this asymmetry between the timing necessary to get registrations and the necessity of taking measures in the metaverse? Thank you.
Great question.
I was just going to toss it too, because I feel like this is sort of what we were talking about last night. Like, what do you even get registrations for, and how you register in those particular classes? So I don't know if you want to sort of recap some of that conversation.
No, that's a really great point. I mean, I think you have to be really proactive in thinking about where might your clients be doing business. What are going to be their core offerings in the metaverse? So are you doing virtual goods and services? Are you, does that mean you should do downloadable software in the nature of virtual goods and services, or virtual apparel, or whatever it's going to be? Should you be in class 25 to be actual apparel? Should you be, are you doing, do you want to be issuing your own tokens, which some clients are doing? That might be more of sort of financial services. So, I think it really puts the onus on the brands to be thinking very proactively, to be getting ahead of the game, registering. I think, you might be filing applications and then they're going to be sitting for a year. But if you have registrations, let's say your client has a bunch of, big IP portfolio, or they've got registrations in Brazil that, go back 20 years, then you've got a new application in Panama, that might be enough to convince, legal counsel for the DAO that, you're a legit brand, and that, you have a better shot of doing that. But definitely be thinking proactive and defensively.
Thank you so much. Thank you for the questions very much. Unfortunately, we're out of time, but this is definitely a matter that we should go deep and discuss more. Thank you very much, everybody.
Yes.